So, good morning, everyone, and welcome back to our weekly webinar series. At episode number 177, we continue our journey to understand the amendments proposed in the IBC Amendment Bill 2025. We also have Mr. 𝐀𝐌𝐄𝐍𝐃𝐌𝐄𝐍𝐓 today with us. A lot of these amendments are having a implication with respect to the ecosystem of IBC, where IBC interacts with the information utilities, and the information utility is, of course, National E-Governance Services Limited, which Mr. Chaudhary heads. Over to Anil sir.
Thank you, Ankit, and welcome to participants to our episode number 177, AAA Weekly Webinar Series. As Ankit said, we are continuing our journey for clause-by-clause discussion on the amendment bill. Today, I welcome Mr. 𝐀𝐌𝐄𝐍𝐃𝐌𝐄𝐍𝐓 Chaudhary, the Managing Director and CEO of NESL, the National E-Governance Services Limited, the company which is presently providing a service which is called information utilities. The role of information utilities have actually again fortified, and again it has now become more meaningful. Therefore, we invited Mr. Chaudhary so that he can explain to all the participants how the information utility records can cut the judicial time and can expedite the admittance and further even claim verification. That this is part 3 of the clause-by-clause discussion on amendment bill. And we are not spending much time on now relating the amendments to different judicial pronouncements, but we would be simply explaining the amendments. Section 33, in fact, regarding initiation of liquidation has undergone a lot of change. First of all, in case we read where the adjudicating authority before the expiry of insolvency resolution process period or maximum period permitted for completion of the corporate insolvency resolution process under section 12, as the case does not receive a resolution plan. Now, what I see, the intent of the amendment are that the liquidation period will also be kind of restricted. It will be restricted, and in case the resolution process exceeds 330 days, thereafter, there will be no power to the adjudicating authority for extending the period further, and it will be mandatory to file a liquidation application. However, if the committee of creditors still think that there is a possibility of resolution, then they can again submit an application. The committee of creditors will submit an application for restarting the CIRP. So what I mean, after 330 days, the adjudicating authority would not have any power. Sorry, after the they see 330 days of the CIRP, the adjudicating authority will not have any power to extend the CIRP period. So therefore, now it is the first amendment is that seen in the red, that the fast track corporate insolvency process under section 56 is deleted, because this fast track CIRP, in any case overall it is deleted. Now then there is another clause which is added, which is clause 4, to subsection 1. Now it says that the subject to the provisions of section 52 declare a moratorium for the purposes referred to in clause A and C of subsection 1 of section read with subsection 3 of section 14, which shall mutatis mutandis apply to the proceedings under this chapter. As per various difficulties, judgments, there was a unclarity about the moratorium available during liquidation process, and what kind of moratorium was available or is available, that is also not fully defined in the code. Now it is codified that during liquidation process, clause A and clause C read with subsection 3, that would be the moratorium which will be applicable during liquidation process. Now, in case we see the clause A and clause C, we can see this: the institution of suits or continuation of pending suits or proceedings against the corporate debtor, including execution of any judgment, decree, or order of any court of law, tribunal, arbitration panel, or any authority, that would be prohibited. That would be prohibited. That is clause A. Then we move on to the clause B, that is not applicable during liquidation, because the clause B is regarding transferring, encumbering, alienating, or disposing of by the corporate debtor any of its asset or any legal rights or beneficial interest therein. Therefore, in liquidation, this is what we do. So therefore, this clause of the section 14 is not applicable in this moratorium, which will be after the liquidation order is passed. Then is the clause C of the section 14. Now, clause C says any action to foreclose, recover, or enforce any security interest created by the corporate debtor in respect of its property, including any action under SARFAESI law. Now, this is also prohibited. However, when this section started, it started with subject to the provisions of section 52. And section 52 is regarding relinquishment of security interest in favor of liquidation estate. Therefore, this particular moratorium, so this particular clause C would be applicable only in case the asset is relinquished. Then in case the asset security interest is relinquished in favor of liquidation estate, then this clause C would be applicable. Otherwise, this clause C would not be applicable. So this is the first amendment in the liquidation process, and also the proviso which says, provided that provisions of this subclause shall not apply to legal proceedings in relation to such transactions as may be notified by central government in consultation with any financial sector regulators or any other authority. So this is where, for any removal of any difficulties, the central government may notify that on these transactions, the moratorium would not be applicable, as the government has taken a decision in the case of aircraft lease in the last about 1 year, and especially in the case of I believe Go Air, where the government has actually allowed the lessors to take away their vessels, to take away their aircrafts from India. So therefore, this kind of notification can be announced, can be notified by central government. So this is what is the amendment in liquidation. Section 14 is applicable. Then this is also pass an order appointing a liquidator. Presently, appointing a liquidator actually was dealt with the another section. For that was also a confusion, that the passing a liquidation order and appointing a liquidator, that is, it has to be one order. Pass an order appointing a liquidator for the liquidation process in accordance with section 34. Now, another subsection 1A is introduced. Now it says, notwithstanding anything contained in subsection 1, where the adjudicating authority is satisfied that the grounds mentioned in clause A or clause B of subsection 1 of this section exist. Now, clause A says that before the expiry, that means no resolution plan was submitted. This is what clause A says, that the no resolution plan was submitted, and clause B says that the resolution plan was submitted but it is rejected. So these are the two, clause A and clause B. So first of all, when this subsection 1A would be applicable, first of all, when the adjudicating authority is satisfied that this company should have been liquidated either because of A or B, means the company is now entitled to be liquidated. One, that the CIRP time is over. Second, the resolution plan is rejected. And as far as clause A is concerned, within 330 days, no resolution plan is submitted. Therefore, the company should be liquidated. Clause B says the resolution plan was submitted, but it was rejected. So what it says that first of all, the adjudicating authority should be satisfied, yes, the CIRP period has expired or the resolution plan has been rejected. Then it shall, before passing the liquidation order, consider an application made by the committee of creditors. That means after 330 days, if committee of creditors would like, then an application will be made by the committee of creditors. And once that application is made by the committee of creditors, then the adjudicating authority shall. Shall means the adjudicating authority will just comply with the COC directions, and it shall. It is not something that the adjudicating authority will only have to see whether this company was due for liquidation, it was entitled for liquidation. Thus, the application made by the committee of creditors in such manner and subject to such conditions as may be specified by not less than 66% of the voting share for restoring the CIRP. And after considering such application,
AAA valuation
it may by an order,
organization ka land and building ke sare partners.
Ankit, you can mute yourself, please.
Sorry.
If the grounds mentioned in clause A of subsection 1 exist, restore the corporate insolvency resolution process to be completed within such duration as it deem fit, but not exceeding 120 days. So there are two situations. I think we have to be
Sir, sorry to interrupt, but you may please continue the PPT. There is same content. You may continue the PPT, please.
So I'm actually sharing this text. Is it not possible to record like this?
No, it is possible. If you want, you may continue with the PPT. I see there's a difficulty. You may continue the PPT. There's the same content, I think.
No, the contents are different. So the PPT contents were not. I'm not referring to the PPT contents. Ankit, I believe these contents are visible.
Yes. Content is visible, sir.
Okay. So in this, I'm trying to explain very carefully that one, after 330 days, the liquidation is possible, but COC has made an application with 66% of voting, again with some conditions. Then the adjudicating authority may extend it for a period which can be any period, 30 days, 60 days, 90 days, but it cannot exceed 120 days. Now, the another clause which says that if the ground mentioned in clause B of subsection exists, clause B means the resolution plan is rejected. If the resolution plan is rejected, then the adjudicating authority even can allow a fresh invitation of resolution plan. That is, the restore the corporate insolvency resolution process to the stage of invitation for submission of a resolution plan, which shall be completed in such manner and subject to such conditions as specified, and the period for this would be again 120 days, not exceeding 120 days. So this is where the liquidation process is going to completely change. After 330 days, the committee of creditors will have to say that yes, we have reasons, it may be reinstated, the CIRP period may be reinstated. So instead of applications for extending CIRP period, it will be an application from committee of creditors for reinstatement of CIRP. That's what is a big change, and this will actually curtail the time of CIRP period in many cases. So the committee of creditors will have to give justification. The committee of creditors will have to appear before the adjudicating authority, give reasons why they could not complete so far and why they are now trying to get an extension or kind of reviving the CIRP period. Now, the explanation is that once this amendment bill becomes effective, it would be applicable prospectively from that date. from that date. Now, the another clause, which is another subsection 1 capital B, has also been added, where the corporate insolvency resolution process of a corporate debtor may be restored in accordance with subsection 1A only once. So this can only be done once. So it cannot be that now 330 days plus maximum 120 days. So that means 450 days is the maximum period that would be allowed. And for the purpose of this section, it is hereby clarified that where the adjudicating authority does not receive a resolution plan during this extended period of 120 days, then or rejects the resolution plan, then the liquidation order would be passed. So there is no possibility that any resolution process can be extended by 450 days. Now, how I'm saying that? First is 180 days. Then the next extension is for 90 days. Next extension maximum can be for 60 days. Now this is 330 days. After 330 days, there is no need for any application. Even the bench, based on an intimation that the 330 days are over and there is no resolution plan which has been submitted, so they can pass an order for liquidating the company. Unless there is a application submitted by committee of creditors for revival of the CIRP period. So this is very important amendment. And again, there is a amendment in subsection 2 which says that where the resolution professional at any time during the CIRP but before the confirmation resolution plan intimate the adjudicating authority of a decision of the committee of creditors to liquidate. Now the word or dissolve has been added. The liquidate or the word dissolve has been added because there are many cases where it has been found by the committee of creditors and the RP and other stakeholders that there are no asset in this company. And there are, if there are no asset, then the company can be dissolved rather than passing a liquidation order. So that is a direct dissolution that is also possible with this amendment in subsection 2 to section 34. Now, this is a very big amendment, and I can only say that yes, I believe one more amendment in section 34, that is the earlier section 34 subsection 5 was there, which was saying that subject to section 52, when a liquidation order has been passed, no suit or other legal proceedings shall be instituted by or against the corporate debtor, provided that a suit or other legal proceeding may be instituted by the liquidator on behalf of the corporate debtor with the prior approval of the adjudicating authority. Now, in this case, this section 5 actually has now been replaced. It has been deleted, and section 6 actually has been replaced. Where a liquidation order has been passed, no suit or other legal proceeding shall be commenced, or if pending at the date of liquidation order, shall be proceeded with by the liquidator or on behalf of the corporate debtor, except with the leave of the adjudicating authority and subject to such terms as adjudicating authority may impose. Now, first, there was an amendment in section 34 that the moratorium would be applicable during liquidation process. And in moratorium, we have seen that no suit or no proceedings can be initiated. Now, in this section, subsection 6, now it says that the whatever proceedings were pending as on the liquidation order date shall be proceeded with by the liquidator on behalf of the corporate debtor. However, the word written is except with the leave of the adjudicating authority and subject to such terms and as the adjudicating authority may impose. It may be interpreted in such manner that it will be the duty of the liquidator to bring all the suits and legal proceedings which are pending as on the date of liquidation order and seek the approval of the adjudicating authority for all the legal proceedings to proceed with all the litigations by the liquidator. This can be interpreted that once the liquidator will definitely ask the adjudicating authority that this is what is the legacy of all the disputes, all the proceedings, suits that I have inherited, I have taken over as on the liquidation date. So I should be permitted to proceed in these cases. Ankit, in case you feel that there can be different meaning to this, otherwise we have finished section 33. This is something which is only a little bit of confusing. One, the moratorium is also, section 14 is available for this. And when we read this section, subsection 6 to 33, then it reads like this. So is it only when the liquidator has to proceed against someone that this adjudicating authority's permission is required, or for even continuing the proceedings, this permission is required?
I think it's basically now they have, I understand that they have said that, or if pending at the time of liquidation order shall be proceeded with by the liquidator on behalf of the corporator. So they have added the pending matters also. So basically the idea here is that the liquidator is expected to go to the adjudicating authority and say that yes, all the legal proceedings that are advantageous to the corporate debtor should continue and others should cease. I believe that is the intention now. Earlier it was that everything will continue and new will not initiate.
Okay, so I think this is all on section 33. Now we move on to section 34. And if I see the kind of PPT that we have made on this, section 33, we have already explained. To summarize, so basically restoration window has been opened. After 330 days, the committee of creditors will restore the CIRP. Liquidation moratorium has been introduced. And then there is a timeline that has been stipulated that within 30 days period, the liquidation order will be passed. And then the COC will be having a role, like COC decisions to dissolve must meet prescribed conditions. And the reinstatement also must meet some conditions. Procedural clarity is important. Fast track CIRP reference is removed, and clearer sequencing of the liquidation order and liquidator appointment that also have been seen. And litigation control, remove old blanket bar on proceedings and replaces with the targeted restrictions on liquidator action needing adjudicating authority leave. That's what I understand. And then in case we move to section 34, that is the appointment of liquidator. Now the existing provision says, the section 34 subsection 1 says that where the adjudicating authority passes an order for liquidation under section 33, the resolution professional for CIRP shall act as the liquidator unless replaced by adjudicating authority on COC recommendation. Unless replaced by adjudicating authority on COC recommendation. And let us see what is the proposal. Now the proposal is the COC by 66% vote may propose the same RP for who was doing CIRP as or PIRP with his consent, or they can choose another insolvency professional with their consent and forward the name to the adjudicating authority. And then then the adjudicating authority will have to appoint that. And the other section is the like the section 34 subsection 3 to subsection 6 says, deals with the personal cooperation disqualification. This is, I think this is similar to that section. I will again go back to the text because the text is important. What is important is that the subsection 1 is completely replaced. Now there is a clear the line of action that first of all, the committee of creditors by way of a 66% vote or voting share will resolve either to propose the same resolution professional appointed for CIRP or for a prepackaged insolvency resolution process subject to written consent, or propose another insolvency professional with a written consent to be appointed as the liquidator, and the adjudicating authority will appoint that particular person as the liquidator. Now, on the appointment, the on the appointment, all the board of directors, key managerial personnel, and partners of the corporate debtor, as the case may be, shall cease to have effect and shall be vested in the liquidator. Now, another clause, subclause, the subsection 3 is introduced to section 34, which says that any person who is or has been personnel of the corporate debtor or its promoter or associated with the management of the corporate debtor or engaged in a contract for service with the corporate debtor. This is similar to the powers of RP. Also, the powers of the liquidator has been changed, shall extend all assistance and cooperation to the liquidator as may be required by him for the purposes of managing the affairs of the corporate debtor or performing the duties conferred on him under this chapter. And the provisions of section 19 shall apply in relation to liquidation and voluntary liquidation process as they apply in relation to corporate insolvency resolution process, with the substitution of references to the liquidator for the references to the IRP or the RP. Now, this means during liquidation also, section 19 subsection 2 application can be submitted to the adjudicating authority seeking cooperation from any person, like all this is mentioned earlier also, so we discussed. So section 19 subsection 2 applications would be possible during liquidation. So then again, this is the so this is where the applicability, again I will say subsection 4 says, notwithstanding anything contained in this section 34A, the resolution professional and appointed for CIRP or PIRP for the corporate debtor, as the case may be, shall be disqualified from being appointed. So the RP will be disqualified in case the resolution plan which was submitted, that was rejected for failure to meet the requirements mentioned in subsection 30 subsection 2. So that in fact clause was earlier also available. Now it has been kind of again in the same line it has been mentioned. Subsection 5 says that where the COC does not forward the name of the proposed liquidator or the board does not confirm, then the adjudicating authority will be appointing a person from the panel. The board shall propose the name of the insolvency professional along with the written consent. So this is all regarding the appointment of RP as a liquidator. See, because there was a confusion that whether the same RP can be appointed as the liquidator of the company or not. So there was a circular from the IBBI. So that circular, in fact, has caused all this confusion. So now this is clarified that all depends upon this committee of creditor. In case the committee of creditor wants the same RP to continue, then they will the adjudicating authority will appoint the same person. If they would like to change it, then they will also appoint the changed one. But the actual decision of the committee of creditors with 66% decision would be valid and it should be adhered to by the adjudicating authority. That's what is the kind of amendment. And then section 34A has been inserted. Section 34 capital A has been inserted, where at any time during liquidation process, the COC of the opinion that the liquidator, now this is a clear-cut authority to replace a liquidator. Earlier, there were many judgments which actually said that there is no provision for replacing a liquidator. Now, the powers are with the committee of creditors for replacing a liquidator. And it is clear that the adjudicating authority will replace and appoint the other person recommended by the committee of creditors. So this is what, Ankit, regarding the 33 and 34. And now I can move to the powers and the duties of the liquidator. So you have anything to add?
No, I believe this is all good in the right direction, and this all kind of is giving clarity to the process, will also minimize the delays in the liquidation process or the issues created because of different resolution professionals appointed, even if COC has given some mandate. So I believe this will give clarity.
So in case we have to summarize, one, that it strengthens COC control on appointment of liquidator. Number two, every time a formal consent is required from the insolvency professional, whether he would like to continue or work as a liquidator or not. Number three, the board oversight is of course definitely required, but then the board has already done by way of a panel. Accountability of the RP is important because in case the RP has not been able to see the resolution plans carefully and the resolution plan is rejected, then he will not be eligible to be appointed as liquidator. Then section 19, subsection 2, section 19 is applicable to the liquidation process also. So the liquidator also would be able to submit an application under section 19 seeking and directions and cooperation from some persons. Though then this in case, so that's what is a complete and replacement of the liquidator actually is now very clear that the COC resolution is important and application to adjudicating authority and the adjudicating authority's approval, that actually is very clear. It formalizes the COC's power to change the liquidator in the mid of the process, ensuring accountability and performance oversight. There is a clear requirement of 66% voting for changing the liquidator. Then of course, before we appoint any person, the pending disciplinary action has to be seen. So now coming to the other part, which is the section 35 regarding the powers and the duties of the liquidator. So existing section says that the liquidator is required to maintain a list of claim of creditors, maintain a list of claims of the creditor. And second, section 35 subsection 1 clause J says to invite and settle claims of creditors and claimants and distribute proceeds in accordance with the provisions of this code. Now in case we see the change, again, I would be very comfortable to see what exactly change has happened, because see, this is whatever is in black, that is an existing part. Whatever has been deleted, that is proposed to be deleted in the bill, and whatever is inserted, that is also shown as inserted here. I hope you are able to see my screen. So the first thing is the liquidator is now to verify claims is not required. Now the liquidator is required to maintain an updated list of claims of creditors in such manner as may be specified. That means some regulations will also come. So the verification part has already been done by the RP during the CIRP, because earlier RP was not supposed to verify, and as per the act, however, as per the regulations, the RP was supposed to verify. Now it is codified that the RP is required to verify and also do the valuation of claims. And during liquidation process, he just has to maintain the updated list of claims and not to invite.
I understand that invitation, maintaining an updated list of claims, when the regulations will talk about this, they will also talk about how the liquidator can take in claims which are received or which were not received earlier. So updation of claims can be very wide. It all depends on how the regulations define it. But yes, this amendment is very clear that this amendment is intended to say that no, verification of claims received is a smaller duty, whereas maintaining an updated list of claims as per regulations is a wider duty. So I think that duty will, of course, be defined under the regulations now. That is the intent of this change. I don't think it will completely abolish the liquidator's duty to call for updated claims or to also maybe get claims which were not received earlier.
So there is another amendment in clause J, where this word invite and, which you can see in red, that has been deleted. No, there is no responsibility of the liquidator to invite claim. Only the duty is to settle claims and also to update the claims, because there is an amendment. The word invite and has been deleted from clause J. So this very clearly says that the liquidator is not supposed to invite any claim. As far as the updation is concerned, we actually need to see that as far as this interest application is concerned, I think whatever RP has done, as far as the interest is concerned, updation means that whatever RP has done, the liquidator may have to add interest for this period and then update the claims. And in case anyone further submits the claim, that is not provided in the liquidation process. that is not provided in the liquidation process. But the another clause L that has also been changed because the total kind of terminology which is now used for the avoidance transaction, only to synchronize that across the code, they have said continue or institute proceedings in respect of an avoidance transaction or fraudulent or wrongful trading. So to investigate the financial affairs of the corporate debtor to determine undervalued or preferential transactions has been deleted. So therefore, earlier it was only undervalued and preferential. Now it is all avoidance transactions or fraudulent or wrongful trading that will to continue or institute proceedings. That is a change. So then the explanation that is added to this is for the purpose of this chapter, it is declared that the provisions of clause A and J of this subsection and section 38 to 42 as amended by this bill shall not apply to the liquidation processes and voluntary liquidation processes initiated on or before the effective date of this bill. So that means that once this bill would be passed and notified, after that, this will be applicable to all the continuing liquidation proceedings. Then another section which is added is the subsection 2, which says the committee of creditors shall supervise the conduct of the liquidation process by the liquidator under chapter 3 of such in such manner as may be specified. Then we can expect further regulations, and the reference to the stakeholders and the consultation to stakeholders has been deleted. So that, see, what I feel, once the COC will come, so all the references in the code regarding consultation and all, then the regulations will also be amended, and all the regulations regarding constitution of stakeholders consultation committee, their meeting, the consultations with them, that will be completely deleted, because see, that work is now being done by the committee of creditors. So this is what exactly we are saying, that this is so this, Ankit, any comment on this?
Yeah, I think this is like, again, widening the powers of the creditors when it comes to verifying the liquidation process or overseeing the liquidation process. So now that it says that they will oversee the affairs of the liquidator as may be prescribed, then the regulations or will define that what are the powers of the COC with respect to regulating the liquidator. So it is wide ambit now. Earlier it was consultation, so that was very limited, that the liquidator will do all this, but he will keep consulting the SEC members. That would have also meant that the liquidator could have said, no, I didn't require any consultation, I knew what I had to do, so I didn't consult them. Then we came at a scenario where certain amendments were made and certain things were said to be required to be approved by the SEC, like appointing a third liquidator or appointing the liquidator, some other issues that were brought in the ambit where SEC had to say yes before things move forward. And now we have another stage where we say that no, SEC will supervise the liquidator. So I believe that the regulations will change such that this will change.
Now, in section 36, which is the section defining liquidation estate, there is a small change, and in that change only to change the terminology across the code. Earlier, the section was any asset or their value recovered through proceedings of avoidance of transactions in accordance with this chapter. Now that has actually been replaced, and it has been replaced with the wording proceedings in respect of an avoidance transaction, fraudulent or wrongful trading. That is, across the code, they have changed the avoidance transaction, and we have separated fraudulent and wrongful trading transaction. Then section 38, section 39, and section 40, section 41 and 42 has been omitted from the code, because see, the claim verification has moved to CIRP process. Claim verification has actually moved to the CIRP process. So the claim verification, which was mentioned in section 38 as consolidation of claim, has been omitted, removed. 39, verification of claim, has been removed. Section 40, admission or rejection of claims has been removed. Section 41, determination of valuation of claims has been removed. Section 42, appeal against liquidator's decision, that has been removed. So whatever has to happen, that will happen during CIRP itself. So during liquidation, that is the reason that the liquidation period is also supposed to be reduced to 180 days only. So now coming again, going see, like we actually have to see even this liquidation period is also now reduced to 180 days. See, coming back to this section, because the time is again like passing. Section 43, subsection 4, regarding preferential period, preferential transaction. Now the look back period has actually been clarified. For the purpose of look back period, as far as this 1 year and 2 year is concerned, that has remained the same. However, the 1 year or 2 year, in fact, will start from filing of the application to adjudicating authority, initiating insolvency process. May it be under section 7, may it be under section 9, or may it be under section 10. So in section 43, all this look back period, now you can say whatever 1 year or 2 year, and then we can add the period which has been taken by the adjudicating authority in deciding the initiation of the process. So that has been added. So there was a kind of advice to various promoters that if you can delay the admission, and if you can delay the admission by 2 years, then you will be out from all your avoidance transactions. That has been plugged now. Even if the application under section 7, 9, or 10 takes 2 years, the look back period will actually get extended. Look back period will get extended, and the 1 year or 2 year period will start from the date on which that application was filed before adjudicating authority. So Ankit, I think it is clear, section 43 and again section 46 regarding the undervalued transactions, again the same provisions, and also under section 47. Now this is very important. Under section 47, presently it is only regarding the undervalued transactions. And what it says that in case the RP or the liquidator is not reporting any undervalued transactions to adjudicating authority, then the creditor can also do this. But now this section has actually been completely changed. It now says that this is the power which is available with any creditor. It is available with the creditor either alone or jointly. Now this power is also available with any member of the company, means any shareholder of the company. It is also available with any partner in case it is LLP. So now any kind of disputes between the shareholders or different promoters, or any kind of dispute between the partners, and if one partner knows that there are some transactions done by the management, that can also be reported by the partner, by the shareholder, by the creditor. Now all transactions can be reported. Earlier it was restricted to avoidance, the undervalued transaction. Now preferential transaction can also be reported by all of them, means creditors, shareholders, and partners. Section 45 transactions and undervalued also can be reported. Extortionate credit transactions can also be reported. Fraudulent and wrongful trading transactions can also be reported. And in that case, if the RP has not reported or the liquidator has not reported, it will have ramifications. In case the transactions are found, and in case the adjudicating authority passes an order and approving that, saying that the application was right, or some order was passed, some relief was granted, then in that case, the adjudicating authority is also given a duty to inform to IBBI for taking disciplinary action against that RP or the liquidator. So this is very, very important that all transactions are reported. If you will not report, creditor may report, or any of the co-promoter, any of the shareholder can report, or any of the partner of the LLP can also report. And if those transactions are reported and found correct, then the RP definitely, the only thing the RP can say that definitely I had no information about the transaction. Even the auditor also could not detect, and I also could not detect, because all these things that I have seen, this is the process I conducted, and I could not find the transaction. However, that has to go to the IBBI. That is the IBBI's decision. In case the IBBI is satisfied that it was a genuine case of not able to find, then IBBI will not take that action, but otherwise action will be taken against the insolvency professional while he was working as RP or the liquidator. Ankit, what do you say about this?
I think this is, of course, putting more responsibility on the liquidator and the RP to kind of be accountable with respect to finding the transaction. So it's a good move that yes, they are accountable. It's not that it is their choice. Okay, they have reported, it's okay. If they have not reported, then also it doesn't matter or doesn't affect them. So I believe this is a good development, a good change that will make this accountability or increase the accountability with respect to finding such transactions. The change with respect to initiation date is also a very welcome change. We used to always find this limitation that 2 years, 3 years was the time period, and this is also one of the reasons why the corporate debtors used to delay the initiation of CRP, because they always were advised, as you said, that okay, if you delay it, then this 2 year period will be ineffective. So now that this is off, they would not use they would not have this incentive to delay the CRP admission. In case the company is insolvent, then perhaps they will go to NCLT and accept that yes, the company is insolvent. Please take this to please initiate CRP, rather than drag the process on account of various reasons.
So there is a little further amendment in section 49, and it is rather expanding a little, and this is also in a kind of influenced by one or two judgments. Presently, it says that any person shall not effect any interest in property which was acquired from a person other than the corporate debtor and was acquired in good faith. Now, see, what was the result of this clause? That there used to be a layering. The first transaction was done with the related party, and then from the related party, it was sold to another third party. Now, earlier it was only the other than corporate debtor. Now they are saying other than corporate debtor or a related party of the corporate debtor, as the case may be. So any person who is buying an asset from the company or from any of the related party will actually have an impact of any kind of fraudulent undervalued transaction. Section 49 deals with the one fraudulent undervalued transactions. So now it is also covered like buying from the corporate debtor or from the related party. So this is what the impact is. I think it is expanding the protection net. That's what the even section 50, we have seen the same. The look back period will have the same thing, like the gap period is covered. The gap or the period between filing of the application and the order of CIRP, that period is now included in that 1 year or 2 year. So this is what is for today. I think we can take a couple of questions in case we have the questions. Ankit.
I think the questions that I have are all dealt with, and I believe that like we can actually see in case there are any further questions next time onwards. I've gone through these questions. I think we can answer these offline since they are not belonging to the topic discussion that we had today.
All right. I think then we conclude. And
yes.
Again, we will continue with the clause by clause discussions. There are very important sections are still left. That is the section 53, which is impacting the distribution in the liquidation process, and also the section 52, relinquishment, whether there is a lot of litigation going on. So that we will deal with the clause 4, our part 4 of the clause by clause discussion.
Great. Thank you. Thank you, everyone. Thank you.